Welcome everyone to this exciting webinar entitled Emerging Legal Recognitions for Multiple Partner Relationships and Families. My name is Skip Harsh. I am the director of the American Bar Association's Commission on Sexual Orientation and Gender Identity. And we are so excited to have all of you in attendance today for this exciting and groundbreaking presentation. I would just like to thank all of our speakers for being here today to present. I know how busy you all are. We're just going to dive right in. I am going to turn it over to Heron Greensmith to introduce themselves and the rest of our distinguished panelists. Please utilize the chat and the Q&A function. If you have questions, please use the Q&A. Chat is open and available for you to give your thoughts and chat with the speakers. Otherwise, I am going to turn off my video and have a great presentation. Thank you all.
Thank you so much, Skip, and thank you all so much for joining us. We are honored and excited and delighted to be here talking about this super emerging topic with you. I'm going to share my screen to get the presentation started. So I want to apologize a little bit. I've had some computer difficulties, so I'm going to be trying to figure out my notes on the fly here. But welcome. Thank you so much to everyone for joining us in this conversation about emerging legal recognition for multi-partner and multi-parent relationships and families today. And thank you to the American Bar Association for helping us out. I'm going to be starting us off here with an introduction to the Polyamory Legal Advocacy Coalition, 4 of whose co-founders you see before you today, and a little introduction to polyamory itself. My name is Heron Greensmith. I'm the Senior Research Analyst for LGBTQI Justice at Political Research Associates. I'm also an adjunct faculty member at Boston University School of Law, where I teach queerness in the law. I'm a founder of PLAC here and a co-founder of ByLaw as well, the affiliation organization for bisexual, pansexual, and other non-monosexual identified law professionals like yourselves. So if you're interested, hit me up on the chat. Speaking of the chat, we'd love to utilize the chat today to introduce ourselves. If you could tell us a little bit about where you're from, what you're interested in learning today, that would be really great. And then if you have any questions for us, I will be scanning the chat for appropriate questions throughout. But if you have any large questions for the whole group or ones that you want to follow up on, please drop them in the Q&A function and we can check that out. We'll have a substantial time for questions and answers at the end of the presentation. Polyamory Legal Advocacy Coalition is a project of the Chosen Family Law Center and the Harvard Law School LGBTQ+ Advocacy Clinic, and is supported by the Committee on Consensual Non-Monogamy within Division 44 at the American Psychological Association. As I said, you see 4 of the 6 co-founders here. We founded PLAC in order to provide a legal need where there was obviously to provide a technical assistance where there was clearly a growing legal need. As you'll see further in the conversation, we've had a couple of municipalities across the United States, only 3 for now, that have passed ordinances either protecting or recognizing families that have more than 2 partners and more than 2 parents. As experts in various areas of the law as it relates to sexual orientation, as the law relates to diverse families, and as many of us as polyamorous people ourselves, we saw the need and we came together. And thank you to Chosen Family Law Center for their incredible work on supporting diverse families. If you're not familiar with Chosen Family Law Center, please look them up right now. And also thank you so much to Alex Chen, Professor Chen, and the Harvard Law School LGBTQ+ Clinic, who is really putting fire under tons of these groundbreaking initiatives. So please follow them as well. All right. I've said a couple of terms already. I've said polyamorous, I've said multi-partner and multi-parent. So one of the things I'm going to provide us here with today is a baseline understanding, shared definitional terms here. So consensual non-monogamy, and unfortunately, I'm gonna have to escape from presenter mode here because this is one of those things that I do not want to mess up. Oh my gosh, look at that slide. I am just presenting you with such a professional thing here. Consensual non-monogamy describes specifically relationships in which all partners agree to have multiple concurrent sexual, intimate, and other relationships. The specific agreements within CNM can vary depending on what the partners need and want. So there are a couple of operational terms there, right? We have all participants explicitly agree to have multiple concurrent relationships of sexual, intimate, or romantic nature. Let me present again. So consensual non-monogamy is our umbrella term. That's the term that you're going to hear a couple of us use, especially Dr. Schlesinger, because it is a social science term that specifically refers to that group of people, people who explicitly agree with one another to have multiple concurrent relationships of romantic or sexual nature. If we move consensual non-monogamy aside, we can see within consensual non-monogamy, we have the families who we refer to as polyamorous. Polyamorous families specifically invoke the idea that you can love more than one person, the amory in love. So while not all consensually non-monogamous people are in love with multiple partners, the subset of polyamorous people, people who identify as polyamorous, identify as having a specific loving relationship with their partners. You have another subset within consensual non-monogamy called families with more than two partners and more than two parents. As you can see, all of those families that we're talking about today are within consensual non-monogamy. They have agreed with their partners explicitly to have concurrent relationships with people. Not all of them identify as polyamorous, nor do all polyamorous people identify as a family with more than two partners or parents. We'll talk a little bit more about those dynamics later on, just to understand that broadly, we're talking about consensually non-monogamous people, some of whom are polyamorous, many of whom are families that have more than two partners and more than two parents. And then overarching this entire conversation is the enormous group of diverse families that include grandparents raising grandchildren, roommates raising one another, sharing mutually interdependent financial relationships with each other, parents, children raising their elderly parents in their household again, fraternities and sororities. You have so many different kinship relationships, especially now that housing prices are so high. The percentage of families that are a biologically related parents with their two children, both different sex couples, is actually the vast minority of families in the United States today. And now to give you a super, super brief current legal landscape, which we will build on much further during Professor Chen's presentation. So right now, there are 3 municipalities in the entire United States that provide legal recognition for families with more than 2 parents or more than 2 partners. There are no municipalities in the United States that prohibit discrimination on the basis of being in a polyamorous relationship. We will talk specifically about the construction of these ordinances, the recognition ordinance and the non-discrimination ordinance, and what terms we use in the non-discrimination ordinance much further fully in the present, more fully further in the presentation. So again, the 3 municipalities that currently provide recognition for more than one other partner in your life are Somerville, Massachusetts, which passed the ordinance in 2020, Arlington, Massachusetts, which passed its ordinance in 2021, and Cambridge, Massachusetts, which passed its ordinance in 2021. The passage of these ordinances also spurred on the formation of PLAC, since we saw that there were some hiccups as people tried to figure out how they can use municipal, state, and federal law to protect the residents of their municipalities. And as you'll see further in the presentation, folks all around the world can actually register in 2 of these municipalities, their multiple partner domestic partnership. We saw that there needed to be a high level of technical assistance, that we can come into these municipalities and others around the country who are looking to pass recognition, and non-discrimination ordinances, and provide them with cutting-edge legal assistance, provide them with cutting-edge evidence from deep empirical research, as you'll see Dr. Setchinger share, and provide them with connection with one another as they build this movement going forward. That was a extremely quickly spoken, very, very high level look at definitions of who polyamorous families are at the current legal landscape, and then what we're going to see throughout the presentation. I'm going to pass it on next to Dr. Setchinger. He's going to introduce himself, and then we will hear from Diana Adams and Professor Chen. I will be moderating the chat throughout. Please don't forget to ask your questions, and we will have substantial time for Q&A at the end. Dr. Setchinger, please take it away.
All right. Thank you, Heron. And my name is Dr. Heath Scheckinger, and I'm a licensed psychologist. I have a private practice and am also affiliate faculty at the Kinsey Institute and co-founder of the American Psychological Association's Division 44 Committee on Consensual Non-Monogamy. And I am notably not speaking on behalf of any of those organizations today. I'm joining you wearing my plaque hat today. So in describing why this is important, I want to start with the obvious first question. By a show of hands or a thumbs up emoji, I want to know how many of you, and next slide, back one slide, one more slide. How many of you have a pet cat? There it is. And so if this group, I see some hands, but if this group reflects the research that one of my colleagues, Dr. Amy Moores, found, that about 1 in 5 of this group has a pet cat. And next slide. Which is pretty close to the national average of how many people have engaged in consensual non-monogamy at some point in their life. So when I share that statistic with other audiences, I typically get one of two responses. One, I had no idea that the consensual non-monogamy community is that large. And two, what the heck is consensual non-monogamy? So thank you to Heron for clarifying that. While it may not be the default relationship structure popularized as a way to conduct romantic relationships, we've seen significant growth in diverse and non-nuclear families and relationships, and we've also seen a significant increase in the number of Americans who are experimenting with different forms of consensual non-monogamy in recent years. Next slide. When it comes to current engagement, around 4 to 5% of the US population is presently in a consensually non-monogamous relationship. A 2017 study found that internet searches related to polyamory and open relationships markedly increased since around 2006. And in a more recent poll, 73% of Americans indicated that they were at least neutral or in favor when they were asked the question of whether they believe society would benefit from moving more toward an open style of monogamy. And in terms of all Americans, 54% of the entire population was neutral or in favor of this as well. And 1/3 of Americans indicated that their ideal relationship is a consensually non-monogamous relationship. Next slide. And some of my colleagues also did a nationally representative study exploring who was likely to engage in consensual non-monogamy. So in essence, the people represented in this study reflect the full demographics of people who live in the United States based on census data. And to many people's surprise, they found absolutely no differences in prior engagement based on, and you can go ahead and do the next slide, or it should come up. No difference in prior engagement based on people's age, religion, political affiliation, race or ethnicity, geographic region, education level, or income. In other words, my colleagues found that just as many leftist college students as they did Southern grandmothers had engaged in consensual non-monogamy at some point in their life. Just as many Democrats as Republicans, and just as many Christians as atheists have been in a ethically non-monogamous relationship. So the stereotypes that people have about who engages in consensual non-monogamy are flat out wrong. The consensual non-monogamy community is nested in every socio-demographic and racial group, every generation, in small towns, in big cities, and reflect the diversity of the people in the United States. So this comes as a surprise because so many people in the non-monogamy community are not out. And they aren't out because of concerns related to societal stigma and discrimination. Next slide, please. And their concerns are understandable. Researchers have found that among people not interested in consensual non-monogamy, 6 out of 7 do not indicate they do not respect people who engage in consensual non-monogamy. And 2 out of 3 people engaged in consensual non-monogamy indicate that they've experienced discrimination based on their relationship status or style. The consensual non-monogamy community has been found to experience discrimination in many different public accommodations and services such as marriage, adoption, healthcare, hospital visitation, workplace, housing, and lending. You'll note that many of those forms of stigma and discrimination reflect those experienced as well by the LGBTQ community. Next slide. And much of the stigma and discrimination that's experienced is rooted in unfound stereotypes and assumptions. One of the common assumptions that people engaged in consensual non-monogamy experience is that they have poor or inferior relationship quality. But in reality, research looking into this, and this is just one study, but there's been many that have replicated this as well, indicate that non-monogamous relationships experience equitable levels of relationship satisfaction, commitment, love, higher levels of trust, and lower levels of jealousy. For example, when people hear of a polyamorous relationship that didn't end well, it tends to confirm a bias that people have against polyamory. See, those relationships don't work or they're too complicated. But when people hear of a monogamous relationship that doesn't end well, they don't tend to blame monogamy like they do polyamory because of the bias that exists and the halo effect that exists for monogamy and the negative biases that exist towards polyamory. Next slide, please. And another stereotype is that consensual non-monogamy adversely affects the stability of families and children. When in reality, what researchers have found is that parental love, care, and respect are the primary factors that influence outcomes with children. Gender, sexual, or relationship orientation are not predictive. Research on children with CNM parents also indicates that they are faring no better or no worse than kids with monogamous parents. As more and more people are moving away from their families of origin, it stands to reason that they are looking for alternative sources of support for raising their children. Imagine some of the benefits that having more than 2 adults available to take responsibility for raising a family. And studies on the topic have found that parents report a number of benefits that you would expect, such as additional financial, emotional, and logistical support with things such as cooking, childcare, and giving children rides to school. And from the kids' perspective, they're indicating a number of benefits as well, such as having additional adults to provide attention, advice, and to give them rides to different events. So as you can see, research highlights how these assumptions are false, but the thing is they're sticky. And what we're discovering is that the stigma and discrimination experienced is pervasive, persistent, but it's also impacting the mental health of the non-monogamous community. Next slide, please. Consensual non-monogamy stigma and discrimination is associated with an increased mental health challenges such as anxiety and depression, and CNM or non-monogamous parents and individuals with multiple marginalized identities are particularly at risk. These realities are starting to be highlighted in research, but I also see them all too often in my private practice. This community is worthy of recognition and support. And that's why, next slide, my colleagues and I have founded the Committee on Consensual Non-Monogamy to generate research, create resources, and promote inclusion of consensually non-monogamous relationships. We're a group of around 60 psychologists, researchers, lawyers, and graduate students who are working to support consensual non-monogamy research, education, and clinical practice. As Heron mentioned, we're housed in Division 44, which is the LGBTQ division of the American Psychological Association. And a few examples of our projects over the past 4 years include publishing multiple studies and creating research-based resources that are the first of their kind for medical and mental health professionals. We've also worked to update the American Psychological Association's guidelines for psychologists working with sexual minorities to be inclusive of the consensual non-monogamy community, and are in the process of proposing a resolution to the American Psychological Association similar to what we will be discussing today. And with that, I will turn it over to my colleague, Diana Adams.
Thank you so much for that, Heath. I feel like I've been speaking about these issues so much with you, and I feel like even I learned something from that. That was extremely helpful. So I'll introduce myself. I have been a lawyer in New York State working with families that are LGBTQ and polyamorous and non-nuclear since I started a boutique law firm in 2007, partly because I was in a queer community and in polyamorous relationships, and people would come to me and ask, where do I go if I'm trying to figure out how to share finances among 3 people or co-parent? And who do I talk to if this is being unfairly used against me in a child custody case? And I couldn't find a legal leader to do that. So that was part of the impetus to meet that unmet legal need and start my law firm, Diana Adams Law and Mediation. And while we still have that private practice, we also saw that there was a pro bono need because there weren't major legislative advocacy organizations and legal services organizations for low-income people meeting the needs of non-nuclear polyamorous partners and platonic partnerships. And so we founded Chosen Family Law Center, a legal nonprofit based in New York. So next slide, please. So with that, I have spent 15 years working with thousands and thousands of people who are creating families that you would think of as beyond the romantic dyad. And I use that term rather than non-traditional because these families are actually traditional, and the nuclear family is actually what's much newer and was really more of an American invention with a breadwinner dad and a stay-at-home mom. It was a way to organize people. It made sense economically. There's a fascinating history to that. But in short, that's a type of family that really peaked in the 1950s and 60s, but has not been the most common family form before or since. Yet it still is the basis for our family law and policy, even though it's not reflective of the actual demographics in our country. And that disconnect is on the rise because we're seeing that more and more families every year are doing something different than a romantic dyad in their first marriage. Only 53% of American adults are currently married, down from 67% in 1990. So we've seen a dramatic shift. And of that 53% of adults, some of them may be in consensually non-monogamous relationships or same-sex relationships. So, or living with extended family. So keep in mind that even with that, half of American adults, many of them are doing something a bit different than what we think of as a traditional nuclear family. And there are at least 35%, some studies say more, of American adults who've never been married. And approximately 40% of American adults are living single. And they may feel like they're not really being addressed in any of our family policy because we focus so much on marriage. And I think that these issues don't just affect the issues of emphasis on marriage, don't just impact those that want to create something a bit different, such as a 3-person partnership, or the many clients I have that are also in step-parent families or blended families. But I think these issues really are allied with the needs of single people whom we saw with the COVID pandemic, for example, may not have anybody that was qualified to take family leave to go take care of them, that may have been extremely isolated, that may not have had somebody appointed to come visit them in the hospital, that may not have had anybody with whom they share their financial information. And those people who are single also deserve to feel the love and support and security of a family structure. I think it's also useful to note that less than half of US children live in a family with two married heterosexual parents in their first marriage. So addressing these issues of needing to expand our family policy is an issue that also would be beneficial to children so that we can create more stability for the families that actually exist rather than try to shoehorn people into the institution of marriage. Next slide, please. I think we'll also see this as we see the demographic shift of more and more people feeling safe to come out as LGBTQ. Fully 15% of Gen Z identify as bisexual or pansexual, and that's only the ones we could survey over 18. We expect that number to continue to increase. As you can see, it's continued to increase over time. And with that freedom to feel safe coming out as lesbian, gay, bisexual, transgender, non-binary, or intersex, we'll also see that more and more people may feel the safety and security to want to be able to come out and identify as being in a consensually non-monogamous relationship and not follow a sort of social script that they need to, finish college, buy a house, get married, that so many of us were taught to follow. Next slide, please. So I think it's useful to note that all family and matrimonial lawyers should expect to see more and more of these family forms on the rise. And all of us, whether we're corporate lawyers, whether we're tax lawyers, we will see more and more people who are LGBTQ and also who are in non-nuclear family forms, more and more people who may be married to one person, but still deeply connected to their ex, who is their co-parent of their child or whom they still care for in disability, even in a heterosexual context. And the people who are consensually non-monogamous and the people who are platonic co-parenting and children who have more than two parental figures is also something that we're seeing more and more of on the rise. Along with assisted reproductive technology and the capacity to do gestational surrogacy to become a biological dad as a gay man or single man, we're also seeing that there are many gay men who don't want to spend $100,000 on that extensive legal process of surrogacy and would rather co-parent with a female same-sex couple or a close female friend. So we're seeing situations of a female same-sex couple and a male same-sex couple who are doing platonic co-parenting as 4, or a male friend and a female same-sex couple who are co-parenting as 3. So I think we should expect to see all of that in addition to polyamory. And I see all of these issues as really allied in one movement for recognition of diverse family structures. Next slide, please. So with that, I think it's useful to note that I mentioned more and more children are living with a third parental figure. And it may sound like this is a very radical idea, but actually, when you think about the rise in step parents who are deeply involved, stepmoms, stepdads who are connected to children, it's becoming more and more recognized right now that a children might have more than 2 people who are legally connected to them as within parental roles, whether or not they are legally or biologically connected officially. And we're also seeing an overall trend in family law from family based on, who provided the sperm or the egg or the womb to intention to be a parent. And so we're seeing a rise right now in what we consider, as some states call it, de facto parent, emotional parent, psychological parent. This is people who've been able to get visitation access, for example, on the basis of having had a relationship like a parent. So for example, if a parent just has a boyfriend or girlfriend or best friend live in the household with them for 5, 6, 7 years and have that person act as a parent, be called a name like a parent, contribute financial support, contribute childcare, they may not be able to sever that relationship by kicking out that person, because we now know the best interest of children are served by keeping connection with people who are in parental roles to them. So I want to show you this interesting map. You can click to the next slide, please. It'll show you some of the diversity, but all of the states labeled in green have acknowledged and given child visitation access, if not full adoptions, to somebody who'd be considered a de facto emotional or psychological parent who's generally a 3rd or 4th person in the child's life. So as you can see, this is actually, it may sound like a bold idea, but it's actually not uncommon at all. You'll also see, though, that as with all of these issues, parenting is now really one of these issues that, like early days of same-sex marriage, was a state-by-state issue in terms of how it was treated. And the states that are in the tan color maybe have some level of recognition, and there's been more of a rejection in the states in orange. There are really helpful maps that are updated regularly on all of these topics at Movement Advancement Project, and I recommend checking that out. Next slide, please. So I want to note with that we see, in addition, in tandem to the movement for multi-partner recognition, we also are seeing more of a movement for third and fourth parents being recognized. And so there are actually a number of states in which third parent adoptions have been accepted. And that usually starts with using a basis of the two means of becoming a parent. Either you could be a legal parent based on being married to the birth mom at the time of the marriage, which enables a female same-sex partner to go on the birth certificate, or being somebody that provided sperm and didn't relinquish their rights and has a biological connection that gives them a legal standing to be a parent. And so in what happens in many of these cases, and has happened successfully in California, Oregon, Massachusetts, and a number of others, is that they will co-parent from the time of birth with a female same-sex couple and that male friend that provided sperm and stuck around and was a dad intentionally. And then by the time the child is 5, they have a progressive social worker do a home study to do a confirmatory third parent adoption to say, yes, all 3 of us are parents. And that's something that I'm hoping to do soon in New York State as well. So that's something that I want to recognize, that we're seeing more of this multi-parent connection. And I think when you're having several people act as parents, it also makes sense for them to be able to stay legally connected between the adults, not just through the child. So with all of these kinds of families, I hear about discrimination in my practice and have to give the bad news that there isn't non-discrimination protection for platonic co-parents, for these 3 or 4 parent families, for polyamorous families. So any of them at this point can be rejected from renting an apartment, from housing, be told you can't talk about that at work. It made somebody uncomfortable. You can even have just a picture on your desk of these 3 people. And so we're seeing the kind of discrimination that Dr. Schlesinger spoke about. And I think that the legal recognition of an adoption, as well as of the multi-partner domestic partnership, really helps to combat that stigma and discrimination, as we saw in the movement for same-sex partnership, that having the legal status of a domestic partnership often helped same-sex couples to get the respect that they deserved from their employers, from their biological family, from their communities. In the meantime, what I have practiced for many years, and other attorneys do as well, is to provide families with support through contract and creating co-parenting agreements that would recognize, for example, if they're trying to co-parent as 3 or 4, that they meet all of the standards that have been used in any states for de facto parenting, emotional parenting, psychological parenting, that they have intended to be a parent from the time of birth, and that they are deeply connected to the child, and then it would be beneficial for the child for them to all have visitation access and say in the child's upbringing, even if they are to split up. And also then in partnerships of 3 or 4, helping to make family contracts to clarify financial entanglement, for example. And I see some of the really challenging issues that face these families when they aren't able to be recognizing the more than one adult in their life. And I'll give you one common example that's not polyamory, but really allied, which is that I have worked with many veterans who may have disability issues, a lot of people who have had traumatic brain injuries or have PTSD, and who are not able to work at their full capacity, and who are married to somebody else, have been married to somebody else who's in the military that has really good benefits and health insurance that they may need. And they may need the financial support of their spouse and partner, but that spouse and partner, they're no longer in a romantic relationship, they're now in a caretaking relationship. And the one client wants to stay connected to their ex who's disabled, and they want to be able to take care of them. But now they have a new relationship with somebody else with full consent and want to be able to keep connected to both of these people. We also see situations in which somebody might say, I'm divorced, but I really like my ex-wife to be able to stay on my health insurance because it benefits me to have the mother of my child get my good health insurance. And she needs it more than my new female partner. So these kinds of issues of having more than one seriously connected adult in your life impact many of my clients beyond the polyamorous triads and quads whom I serve. And I think that's also really helpful to recognize that we've had this assumption that we should be able to share health insurance, for example, with one romantic partner. But I think it's useful for us to really kind of take a step back and think about the assumptions that underlie that in terms of what the most important family bonds are, and why it could be possible for a client of mine, for example, to marry a guy in Vegas one week and then he's on her health insurance the next, but maybe her sister or her best friend who has cancer is not able to access her health insurance. So I think that it's really useful to think about those kinds of cases as well, because I work with many people who are in the platonic partnerships where we may be basing family on either co-parenting a child or on just two adults who are in mutual support who are not in a romantic relationship. That's also a particularly relevant issue for the asexual community that may want to talk about now the fact that they want to be in romantic, or they may want to be in romantic non-sexual relationships, or they may want to be in financially entangled relationships or a close connected family relationship. And I think that we can recognize the reality that many people are forming partnerships that are beyond romance, and that have other kinds of mutual support. And the people who are single deserve that kind of mutual support as well, as I mentioned. And that these kinds of domestic partnerships can actually benefit people who are in other kinds of non-romantic partnerships too. And I remember seeing, as I was involved in the same-sex marriage movement, that it was a shame when some of our domestic partnership policies faded out, because in my experience serving clients, I saw that oftentimes the cities and towns and states would create creative domestic partnerships, and it would be intended for same-sex couples, but many other kinds of people would show up and get registered. And I've seen that with my own client base as well, that you would see that they would maybe write it without any kind of restriction on being related to each other. Some of them say you can't be related to each other in any way that would prohibit marriage, and some of them didn't. And then you would see that two sisters would get domestic partners so that they could share the health insurance. Or you would see two single mothers who are best friends would become domestic partners and work with me to try to combine their finances. You would see also that two elderly widows might want to be domestic partners and have that safe and secure legal connection with someone. And so I thought it was a real shame when, with same-sex marriage, sometimes there would be decisions to, okay, we don't need a domestic partnership anymore. And I think even for a heterosexual monogamous couple, it's extremely useful to have that other option, because one key difference is that in most places, domestic partnership doesn't imply that you're fully becoming a financial unit of two and getting involved in all of the different aspects of marriage. And for some people, that may actually be preferable. And I think that our marriages will be stronger when we can make an intentional choice. When you're going to register at City Hall, having clients actually say, oh, do we want to get married? Do we want to have a domestic partnership? What's the difference? Because I've seen that even many of my clients who are very well educated have not realized the implications of marriage legally, because it's over 1,000 different rights and responsibilities, but nobody reads the fine print on that. And so with the same-sex marriage movement, there was so much celebration in New York when we got same-sex marriage. And then people would come to me, gay couples that got married would come to me and say, oh, I'm a surgeon and he's an out-of-work actor, and we just combined our finances by becoming married. And that's actually really complicated. And we're not really sure that's what we want to do with our relationship, or maybe there's actually a tax hit for doing this. And so people are realizing that, marriage does have all of these other added benefits, but also sometimes aspects such as sharing finances that may complicate relationships in ways that you don't want. And so I think it's just incredibly useful for everyone to recognize the value and the beauty of these domestic partnerships. Next slide, please. So part of my personal thought on this as well, having been very involved in this same-sex marriage movement and having worked with many same-sex couples, as well as many of these other kinds of half of American adults doing something different, that one of the big bases of the same-sex marriage movement was that there are so many benefits and protections under federal law of marriage, for marriage, that if we deprive same-sex couples of this, it amounts to discrimination, because they don't have anybody else for whom they could get citizenship and share their health insurance without having to pay the extra fees you pay when they're a domestic partner, that you get these better tax rates, you can inherit tax-free, that it's such a powerful institution that it's discrimination to deprive people of these important benefits. But I ask you, as we move forward with family policy, why anyone should be denied benefits because they're not in a romantic relationship of which some people disapprove, or because they're one of the 40% of American adults who are single, or because they're basing family on something other than romantic relationship like co-parenting. So I think that part of this movement is not just about supporting polyamorous families, but realizing that polyamorous families and the multi-partner families and the many step-parent families that are out there in America are just part of a diverse array, a beautiful constellation of family forms that all deserve recognition. And so ultimately, I'm more excited about getting our government out of the business of determining who gets citizenship benefits and health insurance benefits and tax benefits based on being in some sort of a Christian institution of which we approve, and rather moving away from that toward a greater freedom of being able to create relationships of choice, and have it not even be a question of whether this is related to the institution of marriage, but rather with the domestic partnerships that we've created, having the possibility for me to go register with maybe my two polyamorous partners, or two other single moms with whom I'm banding together for mutual support, or my co-parent and my current romantic partner, and that nobody's really asking how we're related to each other. What matters is that if adults are willing to show up and support one another, we need that support. And people are wanting that kind of support and that kind of connection beyond a romantic relationship of two. And I've seen the tremendous power in these relationships in my own client base and community. One of the really exciting impacts of the multi-partner domestic partnerships that we've passed with Polyamory Legal Advocacy Coalition that we've been working on is that we've now created a legal precedent in law for legal multi-partnerships. And that's actually come to real impact. Just recently, there was a major decision in New York State, which was West 49th Street LLC versus O'Neill. That was just in September, a month ago, in which a judge it was a rent stabilized apartment, and previously rent stabilization, it passes to a family member. And New York had been progressive about, in Braschi versus Stahl in the late 80s, there was a movement to, it shouldn't just be married couples because these people can't get married. Maybe they can't be as out as we would like them to be, and sort of a movement toward welcoming other kinds of same-sex couples. This recent ruling was really exciting because it said you should be able to pass a rent stabilized apartment onto a polyamorous partner or a platonic partner, because the demographics and realities of families have been changing. And they cited that there's a legal basis in law for these other kinds of families being recognized, and cited these cases, these cities and the town of Arlington in Massachusetts, in which multi-partner domestic partnership has passed. And also quoted from a New Yorker article in which the senior legal director of Chosen Family Law Center, Andy Eisenson, and I were both quoted and paraphrased what we said about the demographics of modern New York City. And so we're seeing that there's really impact for clients, and we're seeing that people in New York City are now recognizing that they could clarify that they have this kind of serious legal relationship by going to Cambridge or Somerville, Massachusetts, and getting registered and coming back. We've also seen with some of my clients that they have had challenges with health insurance, for example, saying, I have one domestic partner, but he or she doesn't actually really need my health insurance. I would like to get domestic partner with this other person, and go to Somerville or Cambridge and come back and say, yes, this person's my domestic partner, and I can only put one person on my health insurance, but I pick this person. So I am already seeing the tremendous amount of helpful impact that this kinds of domestic partnerships have on my client base, as well as the impact that I described of reducing discrimination. And for more on some of the impacts on that, I'd like to turn this over to my wonderful colleague, Dr. Alex Chen from the LGBTQ Advocacy Clinic at Harvard Law School.
Thank you so much to Heron, Diana, and Dr. Schlesinger Heath for your really wonderful contributions to this presentation. And it, is such a pleasure, I think, from the perspective of our clinical program and the perspective of our students to be able to work with such amazing experts and advocates in this field. So I'm here to talk a little bit more specifically about the ways in which the Polyamory Legal Advocacy Coalition has seen fit to plug in on this legal landscape that Diana was just talking about, right? Because, as Diana's presentation just showcased, really the way that American law presumes that there are only two people involved in these types of family relationships, and that those types of structures are the best kinds of ways that the law should organize families, have a tremendous variety of impacts across multiple different areas of American law and policy, multiple different kinds of government entities, agencies, and courts. So in the breadth of all of those things, then what is it that PLAC is focusing on that we think are the best ways that we can sort of move the needle on this landscape? And so first of all, I'll talk a little bit about what our focus has been on to date, which is to say we have really focused on these legislative reforms of passing domestic partnership ordinances and non-discrimination ordinances at the municipal level. And there's a couple of different reasons for that, right? One of the biggest ones is that what Heath has showcased is a massive disconnect between the number of people in our society who have a vested interest in changing these types of existing structures and the structures that are reflected in our government and society. One way to try to protect people legally is through things like writing contracts, right? Private agreements between different small groups of people that they want something different than the norm. There's also attempts to litigate these cases, right? If you are in family court and you're already facing an adverse custodial discrimination, you need a lawyer to come in and defend you to a court and say your biases or uninformed opinions about this particular type of relationship are not well-founded in science or data. But neither of those things necessarily in and of themselves will create a sense that as a society, in terms of a democratic consensus, we're moving away from that norm. Whereas passing laws that are backed by government officials and by the citizenry of these different kinds of municipalities reflects the idea that as a citizenry, we want collectively to recognize the reality of American family relationships and structures, rather than accepting a norm that, as both Diana and Heath showcased, is extremely outdated, right? Historically anachronistic and unique to a particular historical period of time, and that doesn't serve many different groups of people, not just polyamorous people, but also all of the other kinds of groups that Diana and Heath talked about. So that's really why I think PLAC has really focused on the idea that it is important to move domestic law using the venue of politics, right? The belief that really, although these issues feel nascent to the law, they are not nascent in the lived reality of American experience. And they are not nascent when it comes to the challenges that people face as a result of our legal system not working for them, really. And that fundamentally legitimacy of a law system depends on the people who it governs feeling like those laws work for them, right? And we're really just facing a situation in which they are not. And so that's kind of why we've kind of focused in on these particular kinds of legislative reforms that I'm really going to focus in on a little bit in my presentation. But the only other thing I'll say is this: one might ask, you are an LGBTQ plus advocacy clinic. What are you doing advocating on behalf of polyamorous people? It stands for lesbian, gay, bisexual, transgender, and queer plus. What is the commonality of experience here that makes this make sense for a program that really focuses primarily on advocating for LGBTQ plus rights? And there's a couple of different answers we would provide for why we are involved. One of them is that the kinds of discrimination that are faced by people who are in these types of relationships have a lot of parallels to the kinds of discrimination that LGBTQ plus people have faced for their relationships historically, right? Oftentimes there's a sense that these relationships are not beneficial to society, that these relationships are inherently sexual in some way, or that these identities are inherently sexual in some way, that being open about these identities is somehow unprofessional or unwelcome in society, that these types of relationships have a negative impact on children, that these types of relationships are less robust or less healthy. And we are discovering through the research that in a similar way, these are stigmas or biases, but they are not grounded in fact, and they're not grounded in empirical research, right? And so there's a lot of parallels in the way that people are stigmatized in these communities. There's also a lot of practical overlap in these communities. There's an overrepresentation of LGBTQ plus people in these kinds of relationship forms there are lots of speculation about what that may be, right? But one common supposition is that perhaps it is because people who are LGBTQ plus have already questioned some of society's dominant normative assumptions when it comes to the idea that the ideal relationship is one between a man and a woman, And so they are more open, perhaps, to the idea that other stereotypes in society about how relationships ought to be structured are not well-founded. And so in practice, you see an overrepresentation of LGBTQ plus people in these types of relationships. But the reality is that as a civil rights movement, we have really not advocated strongly on behalf of this part of our community. And a big part of that is the reality of the history of the fact that when there was extensive advocacy for equality of relationship recognition for same-sex couples, one common conservative counter argument to that historically was this idea that it would lead to the recognition of things like plural marriages, right? And so I think that historically there was a real fear that advocating on behalf of those parts of our community that engage in CNM practices would lead to an association with another despised and unfavored group that would retard the ability of this movement to succeed in getting access to marriage equality. And so I think there are also historical reasons why we have not advocated fully for the full spectrum of the people in the LGBTQ plus community. And so, in our clinic, we really try to sort of look at what are areas where we are not serving marginalized people within the LGBT plus community, and to sort of try to tip those scales and those balances to try to make sure that that advocacy is happening on behalf of those areas of our community that are more disadvantaged, right? And so I think that's a really big part of why we have come into this work. And, personally, in doing it, what I found to be really interesting is the ways in which, looking to the successes of the LGBTQ plus civil rights movement to date and the strategies that have been used, what ways are those historical parallels helpful? And what ways have those historical parallels taught us something about what we ought to be doing here when it comes to this type of advocacy, but also what kinds of assumptions or examples are not helpful to us in this particular situation. And I'll talk about that a little bit, especially when it comes to the way that we've constructed some of our model language here. All right, so let's go to the next slide. And here, let's talk a little bit about the domestic partnership ordinances that PLAC has been working on. Now, I'm going to use the Cambridge one as an example, but what we have been doing is we've been providing drafting assistance for people in different kinds of communities who are interested in passing these types of ordinances and looking at their municipal codes and how to adapt, our sort of model ordinance language to those different contexts. And doing that, has indicated that there's a lot of, different kinds of interesting legal questions or issues that arise when we're trying to focus on this. So I'll start with first one, which is, how do you even define what are the conditions for somebody to qualify for a domestic partnership? And what's very interesting about this is that if you look at these definitions historically, they often impose higher requirements on someone to enter a domestic partnership than to enter a marriage, right? And so, for example, they traditionally will say something like, in order to register for a domestic partnership, you have to reside together and intend to reside together indefinitely. They often also say, you have to be financially interdependent with each other and intend to support each other financially. Now, so you have to live together and you have to be financially intertwined. At the same time that, Britney Spears and Kevin Federline can just drive to Las Vegas and get married overnight and have nobody ask them any of these questions. Now, why is that? Why is it that marriage is actually much more, has many more rights and protections, has over 1,000 federal laws that govern it, but you can enter into it with no asking of any of these questions? You can just simply walk into a courthouse, get that certificate, and walk out. Whereas for a domestic partnership, you have to agree to all these things. The history of this is actually deeply related to the history of homophobia. Domestic partnerships were first invented in the 1960s and 70s by activists who wanted to find a way to legally protect same-sex couples when there was no prospect that they could get married to each other. And when they did that, there were a lot of questions like, well, what if people just marry their friends? And how do we know that this relationship is real? And how do we know, that you're serious and that you're not just going to do whatever? And so the activists said, okay, what are the things that people think our marriage like? And we are going to say, we're going to hold ourselves to this higher legal standard than is even imposed on married couples to show that gay people are responsible, that they're not just, people who are sexually promiscuous and sort of, engaging in irresponsible behavior. So they really had to, accept a higher level of restrictions that are imposed upon marriage in order to get access to a more limited set of rights. And that has not then been questioned since to say, should those requirements be baked into what a domestic partnership is? Or is there something wrong with the idea that we are imposing higher restrictions to get a lower level of protection? And is it rooted in this history of bias? Right. And so when we worked with cities like Cambridge on changing their domestic partnership ordinances, we didn't just look at how many people can be in them. We also said, look, you should think about these other criteria that you put in and the fact that they come from this historical basis. And so we successfully encourage them to remove the requirement that domestic partners have to live together, which is particularly important in expensive jurisdictions like Cambridge or Somerville, where people can often have a trouble affording cohabitation. Right. And also where that just might not be the structure that they have with each other. We also encourage them to remove requirements about things like financial interdependence. Right. So actually, it's quite interesting because in Cambridge, you can now get registered with fewer requirements. But actually, if you turn around and you try to take that domestic partnership and take it to, say, Harvard University, in order to allow you to place your domestic partner on your healthcare benefits, is going to require you to certify all of those old-fashioned things. Right. And those things that are really not required by any law, but simply this historical artifact that is still present in a lot of these policies. So one thing we've done is change these definitions. You'll notice also that there's no requirement here that people are engaged in a romantic or intimate relationship, that there's a sexual relationship here. We wanted to make sure that the way it was written was open to, for example, to friends who want to cohabitate together to get a level of legal recognition if, say, they want to cohabitate or if they want to raise children together, right? So we really tried to make sure to think about, helping polyamorous people, but also, the wider Venn diagram of diverse families that Heron talked about earlier in that presentation. All right, next slide. So here, I just wanted to briefly touch on issues around registration and withdrawal. Now, this is just a novel legal issue that happens if you have more than two people in a domestic partnership. Cambridge's domestic partnership ordinance now does not have a numerosity requirement for how many people can be domestically partnered with each other. So one issue that comes up that is different is, well, if you only have two people and they want to split up, then the domestic partnership is just over. But say you had three people who are in a domestic partnership with each other, one person wants to exit that relationship. What happens to the other two people? Do they no longer have a domestic partnership? Now, that is a problem from a policy perspective because many domestic partnership ordinances, including this one, say that once you leave one and you don't have one anymore, you have to wait a certain period of time, often 6 months to a year, before you can re-enter another one. But if the domestic partnership is the basis of something like your healthcare benefits, those would also get extinguished, right? And so we needed to work with them to think about how are you going to create a structure municipally for people to register to add or decrease the number of domestic partners. And you'll see that here we suggested this particular apparatus where if they want to amend the number of people in domestic partnership registration, they simply all need to sign and notarize an affidavit under pain of perjury saying that this is the way that they're going to change the number of people on the register, right? So there are these kinds of sort of, finessey sort of, legal issues that are actually very important when it comes to the practical experience of people trying to get these kinds of protections. The other thing that's notable here is that there is no, next slide, please. Sorry, there is no requirement that people live in Cambridge, going back to definitions for 1 second, to get access to these, right? So you can actually live anywhere in the world and come to Cambridge and get access to this type of domestic partnership registration. And we'll talk in a little bit about, what kinds of things you can get if you don't live in Cambridge. But it's very important that both the Cambridge and Somerville ordinances don't actually have a residency requirement and people are able to travel to Massachusetts in order to register domestic partnerships. Another aspect then is what rights do people have? So domestically, when it comes to the municipal level, actually the rights are very limited, especially in Massachusetts, where Massachusetts actually, has state law that currently restricts municipalities from being able to do things like determine what kinds of healthcare benefits people who work for their cities have. And that actually comes out of a case called Connors versus City of Boston, which arose in the same-sex context. And it was a case in which the Massachusetts Judicial Court said, City of Boston, you don't have the right to extend healthcare benefits to same-sex domestic partners that you registered under municipal law. So unfortunately, that's still good law in Massachusetts. So there are certain things that are very restrictive about what municipalities can do. However, there are some specific rights that are actually sort of specified here, including visitation rights, right? So this is a thing that comes up a lot when you talk to people in the community. They're really worried about hospital visitation. What happens to one of my partners if they get into the hospital and we don't have a legal relationship? Typically, unless you are legally married or domestic partner to somebody, or you are their next of kin, you are not allowed to see people. This came up a lot for people during things like COVID. And so this specifically says that within the city of Cambridge, you are able to have these visitation rights if you are registered as domestic partners. There is also a similar statement when it comes to visitation rights for people in correctional facilities. And also, there is a provision that relates to when domestic partners who are also legal guardians of their children and what kinds of access to school records and school personnel that they have. And this is practically speaking very helpful, because oftentimes it is helpful when you are parenting children to be able to have multiple adults who are able to do things like pick them up from school, right? And having this ability to indicate to the school that this person is a registered domestic partner enables for that kind of parenting responsibility to be more easily shared between the two different people who are legally connected to each other. However, as I mentioned, it's not just these rights that are within Cambridge. There are other ways in which it can be helpful. Even if you don't live in Cambridge, if you get this domestic partnership ordinance in Cambridge, you can take it back to your employer in a different state and say, look, this is a legal recognition with domestic partner, and that should satisfy an employer's requirement that you have a legal recognition. Now, as I mentioned, in the context of Harvard University, the employer may impose other extra legal restrictions that would then need reform if you don't qualify for them. But at the very least, you're meeting that legal requirement of having that recognition. Another example is actually recognition in foreign jurisdictions. So we've had at least one situation in which people have been able to domestically partner in Cambridge and use that as evidence of a family tie for the purposes of things like crossing international borders during COVID, which is something that you can only do for people who are legally part of your family. And so even though it might seem very local to just this state that you have these rights, actually there are these very complex and potentially far-reaching legal implications that come from having any entity governmentally in the United States that recognizes these types of relationships. Next slide. So the other kind of ordinance that we're really working on right now are non-discrimination ordinances. And part of the reason that we're working on them is because of a very similar problem that has already arisen, but will continue to arise as we have expanded legal recognition, which is that we are going to enter into a legal world. We are in a legal world where you can do something which is legally recognized by a government, which is to register your relationships with multiple people as one domestic partnership. And you could go back to work the next day and you could get fired for it. Right, which is not dissimilar to after 2015 with the Obergefell decision in the context of same-sex marriage, where same-sex couples were able to get married with each other, but they could go back to work and be fired for it because there weren't any national non-discrimination protections on the basis of sexual orientation. And so we're going to see more and more of this type of problem emerging in the American legal landscape because we have at-will employment, and unless you have a protected basis, you don't have protections against being terminated for something like this. And so we have advanced model language that suggests that people should be protected from discrimination on the basis of what we're calling relationship status, which is a term that we have defined not just to include people who engage in polyamorous relationships, but to encompass traditional marital statuses as well, such as being single, married, separated, or divorced. But also we broadened that definition to include people who belong to these types of communities and don't want to be discriminated against on that basis, and people who are single and do not want to be in relationships with other people. So we've defined it to also include protections for people who are asexual or aromantic, right? So trying to broaden and use this as an opportunity to protect as many different kinds of diverse relationships as possible. To date, we have not yet, we have had some interest, but no municipality has yet passed this non-discrimination ordinance. And that is part of why we are here also today to advocate for the American Bar Association to consider passing a non-discrimination resolution of their own. Next slide. So historically, the American Bar Association has been ahead of the curve when it comes to things like adopting non-discrimination resolutions that have protected people on the basis of different protected categories, including coming out in favor of protections for people on the basis of sexual orientation and basis of gender identity. And here we're asking for the ABA to resolve that people should not be discriminated against on the basis of relationship status as well. And part of the reason that we're advocating for this is that historically what the ABA does in this type of area is very powerful, because it symbolizes what does the legal profession think is a basis upon which people should not be treated worse or differently in American society. And so the ABA coming out with a statement like this that recognizes that, and also recognizes that we have lawyers and law students who are part of this community, and they should not experience this type of discrimination as a matter of their professional experience, as a matter of the professional norms that we have in this profession. That's a really powerful kind of statement to make, especially at this nascent stage when it comes to shifting the law's norms to match society's practices. So we have offered this particular resolution as something for consideration for the American Bar Association. And we are hopeful that this webinar and this series of education conversations that we're having will encourage members of the American Bar Association to support this resolution and its adoption so that we can continue to move the ball forward for these communities.
Thank you so much, Professor Chen. Thank you so much, Dr. Schettinger and Diana, Heath, Alex. I think we're on a first name basis now. I'm going to stop sharing our screen in a couple minutes. Just wanted to give folks the opportunity to write down our website. Please follow us on Twitter and Instagram. We don't share a lot, but it's a great way to get in touch with us. And now I'm going to stop sharing, and I can put those in the chat if anyone needs them later on. Well, that was incredibly comprehensive, and there are so many good questions in the chat. There are a couple construction questions, and there's a couple kind of overarching questions about how legal issues facing these families. There's a couple questions specifically for some of our speakers, but I think I'd like to kind of, I'm going to start with you, Heath. You know, I either saw a TikTok recently or something on Instagram that talked about, instead of identifying the kind of like identity as the mode of oppression, identifying kind of the oppressive frame instead. So instead of saying like, you know, people who are polyamorous face discrimination, saying instead like, we live in a monogamous society, and that means that people who are polyamorous have difficulty moving through it. Could you go through again a couple of the ways in which kind of the monogamous society impacts our families in different ways? Just want to tee up so we can kind of have this conversation about why the non-discrimination protections are so important.
Sure. And I think that, you know, Diana and Alex highlighted a number of these as well with the different examples, but it kind of goes across the board in a number of different domains. I focus a lot on the interpersonal and the mental health impacts. I see a lot of people, one of the main ones is with parents and disclosure to concerns about the impact of their children potentially being discriminated against. I see a lot in terms of the workplace and distress about whether or not people will find out in their workplace, and even just the impact on their relationships, right? And so conflicts or challenges about one partner who wants to be more visible and another partner who doesn't, or who wants their parents to know or wants to be able to attend the event or be recognized when you're with your family or friends as being a partner that's been together for 5 years or whatever it might be, that there are these challenges that come with visibility management, right? And just the expectations of monogamy and how pervasive it is that it, as you're mentioning, that it impacts so many different aspects of people's experience, even attending a holiday party, right? And having to potentially choose, or what does it mean, or how am I supposed to experience it, that we've been together for X number of years and that I can't be formally recognized because it's too impactful of your on your career, right? So I do a lot of focusing on the mental health impact of not being able to formally recognize a relationship. There's certainly stress of the impact as well from a legal standpoint. Another example that comes to mind with parents and, you know, say a grandparent who may not agree with your lifestyle, that is concerns about the safety of your children, that at the end of the day, you're up to the decision of a municipality that you're in, and the potential biases of the judge who's making that decision. And that has a myriad of mental health impacts that we are just beginning to study. Because I would even say one of the challenges is advocating for the field to start measuring this, because we can't address what we're not measuring.
Yeah, we know that mental health obviously has impacts on physical health, has impacts on job performance, and therefore earning. Like mental health has ripples throughout one's life. I'd like to first bring up Hans Brownstein in the chat. I don't know if you saw this. He mentioned that they've been with their partner, who has another partner, for 5 years, but one of Hans's sisters won't let her young children know about Hans's relationship because it is, quote, inherently unstable. So we even have folks in the chat who are facing that exact situation. I'm gonna turn to Diana. Diana, continuing on this, like who else is impacted by these laws? I shared a little bit in the chat about Professor Nancy Polikoff's incredible work on kind of pushing for the +1 framework to rights and responsibilities, pushing for the means tests, right, for rights and responsibilities, rather than just the flipping the on and off switch of marriage. I'd love if you could talk a little bit more about kind of how the needs of specifically consensually non-monogamous people dovetail with the needs of other families that you work with, other families that you know about, and then how all of these families will be supported by non-discrimination protections. Just a couple, just so easy.
Just so easy. I touched on that a little bit, but I think that, essentially, I think it's really useful for people to recognize that anybody that's doing something a little bit different than heterosexual monogamous marriage, nuclear family, which is the majority of us, have something in common in terms of our interests in more inclusivity around family. And we may feel like we are a marginalized community of polyamorous people, consensual non-monogamous people, although 1 in 5 is not that small. Single people, although 40% of American adults is not that small. The many people that with the step parents, and exes with whom they're still entwined, people who care for adults with disability, we can recognize, I think, that we all have something in common for a more inclusive definition of family and the capacity to have the legal registration with whoever is your special legal person or persons that you would want to visit you in the hospital, that you would want to be able to cross a border in a pandemic to visit each other, because that was a really key issue. I lived in Germany, and you couldn't cross the border unless you were one of a small list of legal statuses of family, and domestic partner is on that list. So, the hospital visitation, the visitation in correctional facilities, the capacity to have a legally recognized relationship that then lends credence both to courts and to our communities to just reduce discrimination that he spoke about is so damaging for all of us. So I really see that in many of these kinds of families that I serve, that they're benefited by that kind of legal recognition and that the stability, because what families are ultimately, all of them asking me is my family safe? What can we do to keep us safe? How can I make sure that there's no situation in which my child or my partner or my special person is in the hospital and I can't get there? We all experience that terror with COVID. We all experience the terror of, what happens if there's a border closing and they're in Canada and I'm here? What status do I get to have to say, no, they're actually very important to me, even though we're not married? And so many of these kinds of families just benefit. We all benefit, I think, from a more inclusive definition of family that I think will also make marriages stronger when we have more public recognition that there are other options. There are other options for creating family as an adult. There are other options for creating stability as an adult. And having a person with whom you can share mutual support beyond marriage, I think would help my, many clients who also have gotten into marriage quickly because they thought it was the only way they could be a parent with someone. For example, I think giving people other visible cultural options with the legal stability and credence and respect of a legal designation helps all of us.
And then the legal stability also of having this non-discrimination protections too, so that when you do have the recognition, you're not going to get kicked out of your house the next day, right? You're not going to get kicked out of your job for having the picture on your desk.
Right. And I'll mention more of the non-discrimination that I think that I've heard many situations of people feeling, like their family status is discriminated against. And that includes women who are high-level professionals who are single and feel like they're marginalized for that. women who don't have children, couples that don't have children, people who are living single, people who are living in an extended family network, people who are caring for a disabled person in their household. Many of them feel like there's often, corporate culture, for example, in which they're supposed to be sort of showing up with their wife and kids for events. And if your family looks like something different than that, which for many of us, it does look different, that there's open discrimination that is currently allowed. And it's also really difficult that we continue to sort of zone and build houses with the model of this nuclear family, even though a lot of us are not in the nuclear family. And so many people, myself included, I just tried to rent an apartment in New York City and absolutely met all the financial qualifications and have amazing credit, and had a lot of trouble renting an apartment. And is it because I'm openly gender non-binary and polyamorous? Probably, in some of these cases, yes. So at least not being able to have that open discrimination would help, because I still get calls saying, I just had a picture of my two partners out on the desk at work and was told I'm being transferred to a different office across the country and have to pick up my whole family and move. That can't be legal, can it? And it is. And so giving people that security, I think, is really essential. And there's really some weight and impact to this non-discrimination protection. In addition, in child custody cases that we spoke of, I've done many in which having a relationship status that's stigmatized can really make a huge impact. And so having a non-discrimination protection would, I think, also influence judges, would influence, court evaluators, social workers, all of the people who are making decisions about these families.
Thank you so much, Diana. Alex, I'm going to go to you next. And this is a little bit of a tricky question. So, I researched the anti-LGBT right. And one of my contributions to PLAC is monitoring anti-polyamorous rhetoric. And most of anti-polyamorous rhetoric is pointing to the conversations around marriage equality and freedom to marry and saying, this is the slippery slope that we warned you about. It's happening. So I guess, what is our answer to that slippery slope, and how do we talk about rights and responsibilities instead of in this scarcity-minded framework of there being a slope that apparently, as you go down, the number of rights decrease? I'm not really sure what the rhetorical device there is. Like, if the slope gets slid down, like, I don't know what's going to happen. But how do we respond with abundance, with liberation, and with our communities in mind to this mis and disinformation?
Sure. And actually, I love the question in part because it actually allows me to fold in a couple of the questions that people have asked in the Q&A, right? Because I think, yes, there is this idea of the slippery slope. And the question really is, right, well, what is at the end of the slope, and should we be concerned about it? And I think really it's an opportunity to educate. Because, if you have a parade of horribles and the next horrible on your list is polyamory, then let's talk about polyamory. And let's talk about, is it actually a horrible or is it not? And is there something bad or is there something good about, this community having more legal rights? And frankly, my belief is that, that is a question that is okay to ask, right? It's okay to ask if it's better or worse for society to have a, law system that privileges a dyad versus a law system that privileges diverse family structures. And we should answer that question on the basis of what we learn about what happens when you have different kinds of recognition. And so we have had, for the last 100 years or so, at least, a system that really has privileged a dyadic relationship. And now we are talking about using municipalities as a laboratory of democracy to try a different type of regime and to see what happens if we recognize different things. And what happens if we research these groups and we find out, are these relationships healthy? Are these relationships positive? Are these relationships good for people? And so I don't think that we should be afraid to have these conversations, because we also shouldn't, in my view, be advocating on something that we don't believe in. And we should believe in things because they're true. And so maybe that is my weirdly old-fashioned view of things, but I think that our answers should be guided by what happens if we change these structures, and does it benefit society or does it not benefit society, and how do we measure that? And do we measure that according to a particular view of morality? Should we measure that according to health outcomes? Should we measure that in terms of emotional well-being? Are we using science to answer that question? Are we using data to answer that question? Are we using research to answer that question? So to me, it's not something to be afraid of that there is this scrutiny, because the scrutiny is an opportunity to really open people's minds around what is the reality of the kinds of people we're talking about, and what is the reality of the kinds of things they're trying to do with their lives. And the reality is that it's really quite banal. And there's something maybe a little eye-glazing when we start talking about hospital visitation rights and healthcare benefits and zoning. But actually, these prosaic ingredients are what make up people's lives, right? Where they live, who they work with, how they, relate in society, where their children go to school, where they see their doctor, right? These are the kinds of things that are the building block of a life. And the reality is that people in this community, they really just want to work things out in the context of lives that are really, generally speaking, not really much more exciting than anybody else's life, right? I mean, I think that one thing I found in, being more involved in this work is that I think that there is this popular perception that this might be a wildly exciting way to live. And in reality, it seems to involve even more use of the Outlook calendar than the average person's life. And so I don't know that that's what people imagine, that there would be a lot of use of shared document folders and calendar accounts, but it appears a lot of coordination, frankly. And so actually, I think this opportunity to talk about it in this really nuts and bolts way and say, okay, well, what are people actually asking for? Okay, let's talk about these specific kinds of legal rights and how they help people with doing things like taking care of each other, taking care of children, helping to, support each other. I think that's actually a valuable opportunity. And that relates to this question that I see in the Q&A around, whether or not there should be elements to chosen families being recognized, that should there be some kind of way in which people have to prove the legitimacy of those relationships. And I would say no more and no less than any other kind of relationship in our society. And that the idea that we would have to impose higher requirements on people in these types of relationships comes out of the same kinds of stigmatizing views as the idea that we had to pose higher requirements on same-sex domestic partnerships than on marriages, right? And so I don't think that we should design a system in which we implicitly accept negative stereotypes that are untrue, that these relationships are less authentic or less stable or less healthy, and that you have to sort of meet a higher threshold for this type of relationship to be recognized than any other kind of relationship, because then I think we're really enshrining that kind of bigotry within the law, right? And a similar kind of issue has come up with some employers asking, well, how many people might people want to put onto their health insurance, and what if it's 100 people, and what will we do actuarially if that happens? And one answer to that, I think, is just like functionally, well, we can do it and see what happens practically, because our instinct is that what is going to happen practically is that it is not going to be that, because people are people, and they don't do things that people don't do, right? Like legally contract to be domestically partnered with 100 other people, and to legally have that be something you've officially bound yourself to is actually a pretty onerous thing. When it comes down to, you walk down to that county courthouse and you're actually going to sign that document, you're going to say you're going to link yourself up with that many people. Most people, we think, practically speaking, are not actually going to do that. And the data shows that the vast majority of people are in 3 or 4 person polyamorous relationships. And we also don't restrict the number of other kinds of dependents, right? We don't say we will only cover 3 of your children and no more, because we know that the vast majority of people have only a couple of children, and that it is a restriction on a fundamental type of autonomy to say, hey, we're only going to cover this number of children because otherwise we can't pay for it, right? So we don't want to live in a kind of society where we are, agreeing to those types of restrictions, especially when on an actuarial basis, they're not really going to have a significant impact. And to me, these types of conversations really remind me around early conversations around covering transgender healthcare, right? In the 1970s to 90s, San Francisco became the first municipality in the country to cover transgender healthcare for their employees. And at the beginning, there was this idea that this was actuarially speaking going to be very impactful, and that we would really have to think about the cost it would have on people. And the reality is that they actually created a fund of $2 million to cover these care, something like that, to cover this care, that they actually just abolished 3 years later, because they realized that, yes, transgender people have healthcare needs, but they don't break the bank any more than anybody else's healthcare needs. And, when you kind of actuarially budget for it, I think there was a recent study on private healthcare insurance utilization that showed that for every transgender subscriber being covered under a healthcare plan, the average plan subscriber paid 6 cents more per year. Right. And so, when you actually cost this out, we don't believe you're going to see this monumental impact on society from recognizing these forms of relationships and having more people have access to benefits. And we believe that, we really want to be thoughtful about what kinds of messages are we sending through our legal order when we are designing policy in a particular way.
Thank you so much, Alex. You get so much engagement on that in the chat. I don't know if you want to go through and see, but people really appreciated the shared calendars conversation and talking about the slippery slope fallacy, which we've agreed ends in a kiddie pool full of slime. And if you can find the flag in it, you get to go on to the next level. We only have a couple minutes left. I have some construction questions in here, but honestly, I wanted to give all four of us time to kind of, elucidate a little bit about like what is the most urgent thing that folks can do right now to support consensually non-monogamous families, or to support the American Bar Association taking this step. I'll go first, and then if we each want to go and close. Again, my name is Heron Greensmith. Please access PLAC's socials everywhere. I believe we're Polyamory Legal on Twitter and on Instagram, and at polyamorylegal.org, where you can sign up. I believe you can sign up to be part of our newsletter. Is that correct? Yeah, awesome.
Yes. Also the same thing on Facebook.
And the same thing on Facebook. And then follow Chosen Family Law Center. I'll let Diana Adams share that information. I think the most important and kind of salient chunk of knowledge to take away from today is that, as always, supporting those among us who live at multiple the intersections of multiple marginalities within society will actually support all of us. So supporting consensually non-monogamous families will provide support for grandparents raising grandkids, for friends raising one another, for folks raising adults with disabilities in their households. This is a step that needs to be taken, and the mechanics of it that we're coming to you with are through consensual non-monogamy and through supporting these families that we know and are a large portion of American families. But this will go far beyond impacting just those families. Heath, do you want to go next? We'll just go in the same order.
Sure. Again, my name is Dr. Heath Scheckinger, and the thing that comes to mind is in terms of a practical next step, certainly following us, keeping engaged in the conversation, but I'm also thinking about the tangible efforts that are happening right now, focusing on anti-discrimination in different municipalities as well as in the workplace. So if you're interested in advancing non-discrimination in your workplace, we kind of see that as the lowest hanging fruit or the easiest thing to kind of pass. I see that as being a really strategic next ask or step by the community, is to approach your employer around asking for that. PLAC is in the process of drafting a resource to support you in that process. And then another nonprofit organization called OPEN, the Organization for Polyamory and Ethical Non-Monogamy, it's openlove.org. They're starting a space for employers or employees who want to stay and build conversation about how to advance efforts in their workplace. So that's a space that you can go to and get involved, and you can contact or follow that org, and they will share how to get involved with that effort as well.
Thank you, Diana.
I'll wrap up briefly. It was wonderful to have this conversation with all of you. And you can find us at chosenfamilylawcenter.org. Following on our socials, I'm at Diana Adams ESQ on all social media. And it's really helpful for all of us in these small organizations to get signal boosts on social media when we're trying to fundraise, when we have a survey, when we're trying to get information out, when we have a press release. So there actually is tangible help to being on our social media and sharing things, to being on our newsletters, because then you'll find out, for example, if we're doing something in your area. For example, we may be working with specific municipalities on the anti-discrimination provisions, and we may be asking, is there anybody in this city who knows a city council person? Is there anybody who's in this particular area that wants to get involved? And so we really welcome that participation. And I echo what he said about using the privileges that we have, and people who work at employers who may be willing to adopt an anti-discrimination protection, or who may be interested in signing on to other protections to be supportive of family inclusivity at work. That's a way that you can really leverage some of that privilege. And so get in touch with us if you'd like to work on that.
Thank you so much, Dana. And Alex, why don't you take us out?
Sure. We are our clinic is at Harvard LGBTQ on Twitter, on the web we are at hlslgbtq.org. So we also encourage you to follow our work and to see the kinds of things that we're up to when it comes to impact litigation and policy advocacy. In terms of the ask for folks watching this webinar, one of them is, to the extent that you're members of the American Bar Association or relevant commission, to support the resolution that we are going to be putting forward, and to support it not just in terms of voting, but in terms of the things that you're very likely going to hear from people around you who are part of, who are your fellow colleagues when they hear about this, right? Which are really probably going to be influenced by some of the popular suppositions that Keith laid out. And so really, pointing to this webinar, pointing to Diana's TED Talk, pointing to our organization as resources for people to learn more about how we can be changing American legal system to be something that we can be prouder of, because it is serving more people in our society, right? And I think, one other thing I'll just say to close is there's a lot of fear that's out there right now that people have, that this is a time in which perhaps, there are severe challenges to American democracy, there are severe challenges to American law, and where perhaps many people feel that we may be going backwards when it comes to protections for different types of marginalized groups. And I would say that in that time, it can be tempting to say, we can only conserve the things that have been gained. We can only fight against the attacks that are coming. We could not affirmatively do more to better the way that our society operates for marginalized communities. And my personal viewpoint is that is not the right answer, because it's not enough to simply hang on. It is important to recognize that in order for people to believe in our democratic system, they have to feel like it is changing and growing to work for them. And if we really want to conserve American democracy and the American legal system, people who are everyday people outside of the system need to feel like our country's laws and systems work for them. And we can be a part of changing it even in this way, so that people can believe more that our governmental systems are systems that they want to have governing them.
And on that note, thank you so much, everyone. Please reach out to us. We'll be in touch. If you have any questions, if you have Skip's information, please reach out. I'm sure there are info emails, and thank you so much.
Thank you, everyone.
Bye.
Thanks, everyone. Bye.